I'm Susan Krawczyk, a partner with Eversheds Sutherland.
And I'm Holly Smith.
Welcome to this episode in our videocast series on asset management regulation in 2020. This episode focuses on preparing for compliance with the SEC's new Regulation Best Interest, Reg BI for short, and the Form CRS rules for the relationship summary. The SEC's Reg BI and the Form CRS rules are scheduled to take effect June 30th, 2020. The most recent information from the SEC indicates that the SEC is not considering a delay in the effective date. Of more immediacy, though, both the SEC and FINRA have announced their plans to conduct preparedness exams of broker-dealer firms now, while they are ramping up to comply with the new rules. FINRA's Risk Monitoring and Examination Priorities Letter for 2020 outlines FINRA's plans for conducting exams of member firms for compliance with the new rules. Firms now have insight into what to expect during an exam conducted by FINRA, whether it is a preparedness exam or an exam that's conducted after the new rules take effect.
As Susan just mentioned, the priorities letter is something that everyone should be focusing on now. It lists 9 areas of focus to help a firm prepare for an exam that you may experience between now and June 30th. Among those 9 items, I would tell you that the priorities letter does not really give you any detail other than just telling you that these are things on which you should be focused. For more detail about each of the 9 items and for additional items, you should refer to the FINRA checklist that FINRA published on its website to help firms prepare for Reg BI and Form CRS implementation. Susan, among those 9 items, there are many items that focus on the standard of care. So can you walk us through those particular items?
Sure. Yes, as outlined in the priorities letter, FINRA intends to focus on the procedures a firm will adopt and the training it will provide to its associated persons to assist them in assessing whether recommendations comply with the best interest standard. Another area for focus is how the firm will comply with the best interest standard in the case of account type recommendations. For firms that have agreed to account monitoring, the FINRA will also be focusing on how they apply the best interest standard to explicit and implicit hold recommendations. FINRA also intends to focus on how a firm and its sales reps will consider the new elements of care, skill, and cost when making recommendations. And finally, FINRA is going to focus on how firms and their sales reps consider reasonably available alternatives to their recommendations. Holly, what else is FINRA going to focus on?
So there are 4 remaining items that the priorities letter speaks about. The letter speaks about how a firm and its associated persons plan to guard against excessive trading in the account. And this is a difference from the suitability rule, so everyone should pay particular attention to that. The preparedness exam may also focus on the firm's policies and procedures to comply with the disclosure elements of Reg BI, and also the firm's policies and procedures for addressing conflicts of interest. Lastly, the priorities letter mentions looking at how a firm prepares its Form CRS. It's interesting that of the 9 items, 8 of the items are focused on Reg BI, and only the very last item is focused on Form CRS. So Susan and I aren't great predictors of what those exams are going to be like, but we can tell you that 8 against 1 means that you should be focusing very heavily on preparing for Reg BI and how you're going to demonstrate to FINRA your preparedness for that particular regulation. So thank you for joining us today. For more information on asset management regulation in 2020, please see our other bottom line videos by visiting eversheds-sutherland.com. Thank you.
Thank you.